alright, okay, in jail, to be put in jail or the correction center tu nanti ada principles dia towards the end, alright, why you are put in the jail and not differently. Alright, criminal justice process. This is the second part. Tadi, the system itself consists of all the roles. Alright, now we're looking into the criminal justice process. The process ni they refer to rule, procedure and stages of the proceeding from investigation, crime to the trial and to appeal. These are what you are going to look at. Alright, okay. Now, underlying principles dekat sini, the accused, the principles behind the procedure is that the accused is innocent until proven guilty. On behalf of the one who charged, they must prove the charge beyond reasonable doubt. Barulah bila dua ni match, barulah we call it adversary system in Malaysia. Adversary means memang sistem boleh berdebate in front of a judge. After accused innocent is proven guilty, all right, and the proof of guilty is beyond reasonable doubt, all right, then the accused will be charged. That is the procedure. All right, in short, the procedure is like that. All right, okay, now the criminal litigation process, all right, all right, under the CPC ada 6 process. 6 process ni is the latest one under 2010 amendment. The first one is arrest, second one remand, charge and bail, pre-trial case management, pre-trial and case management. All right, trial and then the post-trial and punishment. All right. Okay, stages of the process before the trial. Sometimes the book would be dividing the process before the trial, during the trial, and after the trial. All right. Okay, yang ini macam mana? This one, criminal litigation process is seen through the stages dia. Tapi the book that I've read, the book that you have bought, the book gives you 3 stages: before the trial, during the trial, and after the trial. Kalau you tengok dekat sini, the 6 stages, arrest and investigation, all right, that is remand and proceeding, that is before the trial. Charge and bail and pre-trial cases, and trial, that is during the trial. And post-trial, that is after the trial. All right, okay, either you classify the process into 6 stages, or you classify the process into before the trial, during the trial, and after the trial. All right, much said on that. Okay, now jadi saya buat dua-dua sekali, ya. All right, so that the latest book, what the latest book says, what the latest situation in Malaysia says, and also what the book have said. Jadi if you read the book or you follow the notes, dua-dua both are correct. All right, now stages process before the trial, or stage 1. Number 1, commission of offense. All right, how do you commission the offense? Through it is being triggered, or a report is lodged, usually by the police. Yeah. All right. Now the lodged report, that will be the vital evidence number 1, that you have the mission to carry out the investigation, which is a process before the trial. In the investigation, you have the power to interrogate and search and seizure, arrest, charge, bail, and plea bargaining. All right, let's look into investigation, because Malaysia is an adversary system. All right, kita bukan, we are not inquisitorial system. Now, what is the difference? Adversary system are all the system under Commonwealth country. They allow debate, they allow free debate between the defender and the lawyer and the prosecutor of the victims in front of a judge. All right, okay, they are physically facing each other in court. That is the adversary, macam nak pergi bertumbuk macam tu. All right, okay, inquisitorial system in Europe, these are system based on civil law country. Common law country are all the British Commonwealth country. All right, okay, the inquisitorial system are all the civil law country, usually it's affected the European. All right, France, Germany, Italy, and Thailand. There are civil law countries. Inquisitorial system is when they use inquiries report. I write 12 questions, I send it to the accused, or I send it to the suspect. All right, they will answer it. It take about 48 hours, or nothing is direct. All right, everything is through that. Either you use the email or whatever, the question come first, and then they read the question answers and the question in court in front of the judge. Macam tu, inquisitorial system. They move slowly, but everything has to be, all right, written or set in the email. All right, because, and then it cannot be answered promptly, not there. The person who received the questions must be given at least 24 hours to think of the answers, because the answers will then be implicated on the person who answers it, as usually the accused. I asked the accused a question. Accused in the civil law inquisitorial system is given at least 24 hours to figure out the answer, even though he can answer it quickly. Why? Because the answer he wrote later on will be used against him. All right, that is in the European system. Why is like that? Because in Europe, all right, right must be given. Justice to them is when they allow a little bit of time given. Yeah, right. They have human rights. You can't be made to answer, all right, quickly. In our court adversary system, you just have to answer quickly. And sometimes when you are quiet, the court wants you to answer there and then. All right, that's a difference in the system only. All right, both are going to bring justice. Right, prosecutor are not investigator and are not involved in the investigation. Pada waktu ni, all right, prosecutor, it's not in the picture. Stage 1, investigation. All right, there are 2 types of offense which the police may arrest with or without warrant. Right, okay, now 24 hours, the police have time to complete the investigation. 24 hours. If the police wanted more than 24 hours, all right, either to interrogate or to, all right, bring the suspect back to the police station, they would need a permission from the court. That is where I put there. All right, if the investigation cannot be completed within 24 hours, the police may apply to the court for the suspected person to be held and remanded under section 117 of the Criminal Procedure Code. All right, section 117. Again, as I said before, these are the sections that I haven't cross-checked with 2010 to see whether it is the same section to allow the person who is a suspect to be remanded in the custody of the police. All right. According to the Police Act, when they were carrying out investigation, they will have the Police Act in their hand. They can investigate and then they can arrest the suspect. Nampak tu? Arrest the suspect. Bawah Police Act, bukan bawah Penal Code. Right? Okay. Now, Police Act allow investigation and arrest suspect. Investigation can commence from the complaint or info or response to emergency call. Right? Okay, sometimes, all right, they get, bukan daripada emergency call saja, they get a call from the hospital. All right, let's say, for example, all right, you come into the hospital with a crack on your head, all right, and then when the doctor asks you, oh, why is your head, you know, after treating you and all that, they will run these inquiries that is compulsory for the doctor to do it. The doctor asks you, who hurt, how do you get your head hurt? All right, and you say, oh, my husband, he just take the axe and he swung at me. All right, okay, that is also a start of the right, report. The doctor will write that in his report, and the report will then be, all right, sent to the hospital. Whether you love your husband or not, you want to charge your husband or not, if the doctor have reported it out, all right, that would be a start comments, all right, a trigger to the investigation to carry out, all right, okay. Now, so therefore, all right, you have to make sure you sometimes in this situation, all right, you simply just say your husband, what if you say your husband or your partner accidentally, you know, swung the knife and hurt you? It may be an accident, but the police will go and investigate. If there really no intention to hurt, all right, probably the case will be considered as accident. If not, it will be considered as crime. Yeah, all right, investigation. Again, I'm repeating kat sini, IO would visit the crime scene. Visit the crime scene. All right, and then inquire of the facts and circumstances, locate the evidence, all right, okay, and then lepas tu can order witness to go to for questioning. Kita panggil apa? Interview. All right, okay. In the stage in the criminal justice during the trial. Now, in most seizable offence which carry imprisonment of less than 14 years, the magistrate may allow 4 days. Kan tadi dia nak suruh, yeah, you know, you cannot complete it in 24 hours. Now you go to the magistrate, ask for the remand, all right, okay, and remand will be up to 4 days. Jadi, are you in this stage an accused? No, you are only a suspect. All right, and if in 3 days, in 4 days, it's not enough, they can hold you another 3 days. All right, okay. For offense punishable with death or imprisonment of 14 years or more. All right, okay. Case you apa? Ada ke 14 years or more? Ada, isn't it? All right, okay. That is CBT. Boleh up to the maximum berapa? Okay. The detention shall not be more than 7 days. Nampak tu? For ordinary situation, it is up to 7 days altogether. But in this situation, the second situation that it involves death or imprisonment, okay, you can be held up to, all right, 14 days. All right, search warrant. Tadi kita kata apa? Police can do that. Police can search. All right, when a police wanted to go for search warrant, that is my section. All right, okay, section okay, 554 of the CPC. All right, the investigation officer believe. Ni nampak ni the word believe. He believe. All right, okay, the person has been ordered to submit document, will not produce it. You nak buat lari the document. All right, you want to run away with the document, then he can get warrant, search warrant from the magistrate to search the premises. Search warrant is only valid for reasonable days. Right, it's not forever. All right, the date will be determined there. The search warrant, all right, search without warrant, section 50, for search with warrant, section 54, all right, search without it is section 62, all right. Now, in exam, you don't have to put the section. For you, you are not law student, all right, you just have to say there are 2 types of search warrant that will go to the premises. One is with warrant, the other one is without. All right, once you search, then you can seize. All right, seize. All right, once you search, you can seize. Power to enter, power to seize. You boleh masuk rumah tu, all right, okay, locate and collect. Pergi bongkar segala-galanya, you turn the place upside down, all right, and then you go out with the evidence that you want or the document that you want, all right. All right, why do you want to go there search? Because the action that you found, the evidence inside the place or the premises related to the accused, that shows that the accused is, all right, guilty. All right, but this guilt, it's only by the, okay, apa tu, alter virus. All right, mens rea and anybody wants to add the second one? Mens rea is the intention, all right? The other one is apa? Actus reus. All right. So when the goods is in the premises of the suspect, when the items or the document or the money is with in the possession of the suspect, then in this situation we say the actus reus have already taken place. All right. All right.